16th affirmative defense after acquired evidence. Plaintiff moves to strike defendants after acquired evidence affirmative defense pursuant to Federal Rule Civil Procedure 12F as frivolous, inapplicable, and impertinent. This is a 42 U.S.C. 1983 action for constitutional rights violations against municipal and state actors, not an employment case. Plaintiff is not, has never been, and will never be an employee or employer of any defendant. The defense applies employment discrimination statutes, and no federal court has ever extended after acquired evidence to Section 1983 constitutional claims outside the employer-employee context. Constitutional violations by government actors are complete when committed and cannot be retroactively justified by subsequently discovered evidence. The defense is impertinent as it seeks to import irrelevant employment law concepts into constitutional civil rights litigation where they have no legal basis. Allowing this defense to be reserved would prejudice plaintiff by granting defendants license to engage in a fishing expedition that would force her to defend against the merits of a legally baseless defense without the ability to strike it. It would also allow defendants discovery access into plaintiff's personal life under the guise of a reserved affirmative defense, which would violate Federal Rule Civil Procedure 1's requirement of just, speedy, and inexpensive determination of cases by creating costly, burdensome, and irrelevant discovery that causes delay and would not go to the merits of the constitutional claims, while potentially requiring protective orders to prevent abuse. This defense is an improper attempt to search plaintiff's personal life to show she is a bad person, to justify or limit defendant's constitutional violations when plaintiff's previous convictions, previous employment, previous traffic tickets, or any other previous acts are completely irrelevant to this constitutional rights action under 42 U.S.C. 1983 and cannot excuse government actors' deliberate violations of plaintiff's constitutional rights. 17th affirmative defense, Heck v. Humphrey. The Heck doctrine does not apply to plaintiff's claims because they do not challenge the validity or legality of any criminal conviction. The county court dismissed all charges in July 2023 after finding constitutional violations, meaning there is no conviction to be invalid, even if there had been a conviction. Plaintiff Section 1983 claim seeks redress for violations of secured rights. Success on plaintiff's claims would not necessarily imply the invalidity of any conviction as required by Heck because they address procedural violations and retaliatory conduct that are independent of guilt or innocence on the underlying issues. As the Supreme Court stated, if the district court determines that the plaintiff's action, even if successful, would or will not demonstrate the invalidity of any outstanding criminal judgment against the plaintiff, the action should be allowed to proceed. Here, there is no outstanding criminal judgment, and the constitutional violations complained of are independent of the merits of any criminal charges. Affirmative defenses that only fail Woodfield. Second affirmative defense, statute of limitations. Plaintiffs move to strike defendants' first affirmative defense as insufficient under Federal Rule Civil Procedure 8C and 12F because defendants bear assertion that plaintiffs' claims are barred by the applicable statute of limitations, fails to identify the specific statute invoked when the cause of action allegedly accrued in the applicable limitations period, or any factual basis supporting the defense, thereby depriving plaintiff of fair notice of this critical affirmative defense. Defendant's conclusory statute of limitations defense fails to identify the applicable Mississippi statute, accrual date, or factual basis for untimeliness violating Rule 8C specificity requirement. The Supreme Court requires defendants to specify accrual under federal law and the relevant state limitations period. Without these details, the defense provides no fair notice and warrant striking. Because no specified federal statute of limitations exists for Section 1983 suits, Federal courts borrow the form states general or residual personal injury limitations period, which in Mississippi is 3 years. That's Edmonds v. Octavia. Fifth affirmative defense, no municipal liability. Defendant's fifth affirmative defense merely states that municipal defendants are not liable under the theories alleged by plaintiff, providing no factual basis whatsoever for this conclusory assertion. Under Woodfield, affirmative defenses must be pleaded with sufficient specificity to give the plaintiff fair notice, which requires factual articulation sufficient to prevent unfair surprise. This bare legal conclusion violates Rule 8b's requirement for factual matters showing entitlement to avoidance. Instead, defendants force plaintiff to guess their theory of non-liability, whether based on lack of policy, absence of custom, proper supervision, or other grounds. Moreover, the defense creates irreconcilable contradictions requiring factual development that cannot proceed without fair notice of defendant's position. If Stewart acted independently, this suggests municipal supervisory liability for failure to train or supervise. If he acted with authority as final policymaker, his actions create direct liability. The current pleading identifies neither theory, preventing meaningful discovery while creating unfair surprise. The defense should therefore be stricken for failure to meet basic pleading requirements, though factual development through properly noticed discovery may ultimately be necessary to resolve municipal liability questions.